and your business as it grows. I would like to say a massive thank you to Collyer Bristow and the team there. Sharon, you and your team. It's been a delight to work with Collyer Bristow on a series of events around really, really relevant, meaty topics that pertain to how you can support your business as it grows. Obviously, the legal aspects are very, very important, and often things that we get caught short on afterwards, rather than looking at how we can deal with them proactively. And so Collyer Bristow, as many of you know, is a law firm that really champions ambitious entrepreneurs. They have a very strong focus on supporting women in business, which is why we've partnered with them on this series of events. And they've provided incredible support to us as a business as we've grown. We really love their approach. So Sharon and the Collyer Bristow team, thank you very much for today. Before I hand over to Sharon, who's going to be kind of leading the session, and I know that she's going to be introducing some of her colleagues to cover specific areas, I would just like to remind you, in terms of house rules, if you can keep your microphones on mute, just to minimize any of the background noise. We are recording the session, so you will have access to this afterwards. I will circulate a link. And I know that the Collyer Bristow team have also pulled together some resources that they will be sharing with us afterwards, a really helpful checklist. And in terms of questions as we go along, I'll be keeping an eye on the chat. So if you've got questions, please do pop them in there. We'll have members of the team that will be answering them. But obviously, if there's anything that's really relevant to what's being discussed at the time, I will kind of stop Sharon and say, you know, actually, we've had a question that really relates to this and it might be worth answering it now. And then we'll have some time at the end where we can address all the questions that have been asked. And if by any chance we don't get to all of them, we will send around a transcript afterwards of all the questions with answers to those. So that'll be an additional resource for you. So I think without further ado, we've got a fair amount of people in the room. Again, thank you so much for making time to join us today. I have no doubt that this is going to be a very, very valuable use of your time, an investment in yourself and your business. So thank you very much. Sharon, I'd like to hand over to you because I know that you're going to introduce the rest of the team members that are involved in the session today and to outline the content that we're going to be covering. So thank you very much. Over to you.
Thanks, Michelle, for that very kind introduction. And we're all delighted to be joining you today for this session. So thank you to all of you for joining us, because it fits so well with our firm's specialisation in acting for entrepreneurs, both in relation to their business and also in protecting and passing on the value that you have created. So I'm going to start by talking a little bit about the legal ownership of a business and how that can be structured, particularly as new investors, as well as just your own savings. And we did a little survey before this event and found out that most of you are supporting your business through your own savings, but starting to get some support from other places, from friends and family, from external investors. So it's important to think about how that's structured to protect yourself and what you have created. My colleague Louise will then guide you through some suggestions to preserve the value of your hard work, things that you need to know as an individual, as well as the owner and manager of a company. And last but by no means least, as you'll have heard from a number of the other presentations that have operated in this series, the importance of protecting your brand and some ideas for how to go about doing that, presented by Cecile and Meta. As Michelle said, there will be time at the end for questions and for discussion. But if anything is unclear as we go through, and it might be better to quickly answer that question in context, do please chip in a question and we'll address that live and in real time. We will aim to finish on time in not more than the hour that you have scheduled in your busy calendar. So it will have to be an overview from all of us, but we'll find a way to get back to you for any questions that we don't manage to get to this morning. And Michelle will circulate our contact details afterwards, so you can follow up with anything more individual and specific to your business if you don't want to do that in the wider group. So without further ado, I will try and share my screen with you just for a few diagrams to help you picture what we are talking about. There we are. So you have, oh, there we go. You've spotted an opportunity in the market. You've got something that people want. You have done some proof of concept, and you know that this is really going to be a success. It's now sensible, I would suggest, to start looking at doing that through an entity of its own. Typically in the UK, that's done through a limited liability company, which are quite quick, quite cheap, quite easy to set up. Mainly because that gives the business its own identity, its own track record, which will be important for investors to be able to see in the future, to be able to invest in your business. They want to see that it has its own identity, its own success. And also for banks, they'll want to see business plans, they'll want to see income and outgoings neatly and clearly separated between your assets and life and the business and its own life. The same thing can apply at different stages of your business. If you're doing more than one thing in your company, you might want to consider packaging those up into separate companies. Makes it more attractive to a potential buyer if they are able to take an entity, a self-contained thing that makes sense to them, and that they can see value in and how it would react and integrate well with their existing plans. As I said, there are a number of ways of achieving that sort of separation, but by far the most popular is the limited liability company. So I'm going to focus on corporate structures for the rest of this session. As you might be aware, when you have a company, there are company directors. The directors have day-to-day operational control of the business. They're running the business. They're normally executive in the business. You may have some directors who are non-executive, who contribute a few hours and provide an overview and a guidance and a steer. And as businesses get more mature, they do often have those sort of advisory directors. I have a client of mine once describing his role as non-executive directors did say that, yes, non-executive directors, a bit like B-days. Nobody's quite sure what they're for, but it adds a touch of class if you've got one. But in the real world, actually, a good non-executive, somebody who's effectively a bit of a mentor and providing a sanity check and a step back, could be very useful. Directors have legal duties. Under the UK legislation, you've got a duty to act in the best interests of your company. That means being very careful about the difference between the company's assets and your personal assets. On the other hand, the flip side of that is that you get the benefit as a company of limited liability risk. So while you can't dip into the company's money for your own needs, unless you're able to do that in one of the legitimate ways of salary or dividends, typically, it does also mean that the company's liabilities are restricted to the assets that have been put into the company. So how does the company get those assets? It comes from its shareholders. The shareholders own the business, and the shareholders ultimately control the business. They can tell the directors what to do. Sorry. However, there we go. As a shareholder, what do you get? What does it mean to be a shareholder in a company? Typically, there are three things that go with owning shares in a company. There are voting rights, there's the right to income as you go along, and there's a right to capital. If your company is sold or the company is wound up, anything that's left in the company, how does that get divided up? Really important to notice that there's no necessary connection between all three of those things. It is possible to split them up. So when you hear of somebody on Dragon's Den and the like saying 20% of my company, what does that mean? Could mean any of a range of permutations of things. It's your company, and if you've got an investor coming in who backs you and who backs what you're doing, they may want fewer voting rights. They may be happy for you to run that company as you see fit. They trust you to do that. They'll only want votes on the big decisions. They may want to have a regular income. That sometimes happens where parties have somebody's got money to put in and somebody's got time to put in. Your time you want to have rewarded, so you'll get that by way of dividends as you go along. If you've got a longer term investor, they'll put in capital and they will only get their reward at some future point when the business is sold. So it's important to think about what goes into the business and in what capacity. That flexibility is a real strength of the private limited company. Different people can contribute different things and get different things out. That's typically done by, when you get to that point, you'll hear it described as share classes. Not like classes on a train, so they won't be called first, second, and third. They'll typically be given letters rather than numbers, because no one class is better than the other. The object is to give each participant what it is that they most want. That can also be used in being fair to successive generations in the same business. Perhaps some of you will have come across that on family companies, where some people are very active in the day-to-day business and others are only more distant, but get their benefit from the family business purely in the way of cash. This can also be done to incentivize and to motivate the next level of management team coming into the business to really feel that they've got a stake in the business. So you can give them rewards based on the company's performance, so that as the company grows and as the company progresses, it's not just their salary, they've got a real personal stake in making this a success. Also, having a good management team ready to step into your shoes is one of the best ways for you to plan, perhaps, for an exit, that you can step away and perhaps become one of those non-executive type directors that I described for your own business, because you'll understand it, but you don't need to be quite so hands-on every day. And that will enable you to free up some time and to free up some capital by selling your shares to some of the other participants. But as I mentioned, with the voting rights, you can still keep a level of control and a level of influence that you are comfortable with. And we've heard that on a number of other presentations of individuals who've grown up a business, and see it with their name on it, but no longer theirs. And so they can no longer control the direction. Having a separate class of share that you keep one or two of gives you at least the ability to steer and guide that, even if you have realized some of the cash.
Sharon, can I chip in and ask a question?
No, please.
Is it advisable at the point of kind of determining the share capital and the classes of shares, etc., to have legal advice around that? So, because I guess many founders assume that as the original founders of the business, that they will not be disadvantaged in any way, but I'm sure that it happens sometimes that you can put yourself in a vulnerable position without realizing it when you're issuing share capital.
Absolutely. Thank you. Thanks, Michelle, for pointing it out. That's a really good point. And I would say that, wouldn't I, being a lawyer, but it is important to have this done quite formally and by somebody who knows what they're doing to prevent any arguments later on. As I said right at the sort of introduction to this section, if you don't do anything different and everybody gets the same class of shares, then everybody has voting rights, income rights, and capital rights strictly in line with how many shares they own. So if there are 100 shares in the company and you own 50 of them and somebody else owns 50 of them, they've got exactly equal voting rights with you. If somebody else owns 51%, then they can outvote you. But with the right share class rights, it's possible for you to keep that level of control as a founder. And it does often happen that there are founder shares as a separate as a separate class, giving you, the founder, those extra rights. Because otherwise you might find, if you're very grateful to somebody at an early stage who's putting in money, at the point they put in the cash, that might be worth 20% of your business, but that means they'll get 20% of everything going forward. And if you want to bring in new investors, that will continue to chip away at your rights. So somebody for a relatively small investment, if they're in early enough, could end up seeing an awful lot of what should be your value at the end. So you might look at limiting their return to the amount that they put in plus a particular percentage, rather than 20% of everything forever out to the horizon.
Okay, great. Thank you. That's really helpful.
Which brings me on, I suppose, to the next thing about shares. They are, in principle, freely transferable unless you set out something else. It's likely, particularly in a smaller company, in big PLCs, anybody can buy and sell shares. Nobody really cares because there are so many people that personality clashes and differences of opinion kind of smooth out across the numbers. But if it's just you and one or two carefully chosen individuals, you don't want to find yourself in the position of working with an investor that you're not expecting because they've passed their shares on to somebody else. Equally, those investors don't want to find that you have exited because they're investing because they trust in you. Therefore, when you're setting up these rights, you may want to look at putting in restrictions on transfer. It's common to allow people to transfer to connected parties for tax planning, particularly in family situations. That might be to a spouse. It might also be in the context of intergenerational businesses, to be able to pass on your shares to your children who are coming through in the business. You wouldn't want to be restricted from doing that. And otherwise, you might have what we in the legal jargon refer to as preemption rights. So if somebody wants to sell, they first have to offer those shares to the other shareholders to see if they would like to increase their stake or buy back some of their shares. You might, after that has happened, want to allow others to sell if they've offered around, nobody else wants to buy, and they can find somebody else who's willing to buy. Are they trapped holding on to their shares unwillingly? In some cases, you might have an absolute prohibition. In private companies, that is not unusual. Or you might allow a sale to a person, as long as it's somebody that you approve of and feel that you could work with. But the overall message, I would say, is consider putting some restrictions on transfer so that you don't end up with an unpleasant surprise.
Yeah, I think that's a really important point on the investment side, because if, as you quite rightly said, you don't want to land up in a position where somebody, where you're having to consider an investor that you're not getting on with because they took over shares from somebody else. And I think definitely from some of the feedback we've had in our community, it's a common pitfall of taking on investment is not being really 100% sure of the relationship that you have with the investor. I mean, I think somebody once gave the example that you should be comfortable going out for dinner or lunch with your investor like virtually on a daily basis. Obviously that's unlikely to happen, but you've got to be that comfortable with them. And I suppose you could land up in that situation with having someone that you don't get along with, having a controlling stake or say in your business.
Yeah, and sometimes, depending on the situation of the business, you're prepared to do that for the cash if you know that it's a short-term situation. So, for example, I've seen venture capital investors in a business, and I'll not name any names, but the individuals did not get along well at all. But they were doing this very clearly on a not more than 3-year business plan, and then we are all going to exit. So they are actively pushing to an exit. And that is probably the only point in a client exit meeting where I've had to stop the client and the private equity investor from coming to blows. And I'm quite short, and they are big blokes. Like, don't hit him. It's not going to help. You've only got to do this for a few more hours. It was right at the exit, and they had had enough of each other. That's not ideal. I can only think of one example where that has really got to such a level of friction. But that leads me quite nicely on to the next question, an obligation to transfer. What happens if you really can't get along with somebody anymore, that there is that level of friction? Is there a mechanism to bring the relationship to a close? That most often happens if somebody has been working in the business and has got some shares because they're working in the business, but they want to leave, or indeed have to leave. The most common way that's described is good leaver and bad leaver. Doesn't necessarily make any moral judgment on the individual. It's the circumstances of the leaving and the consequences of the circumstances in which you leave. A good leaver is typically somebody who has ceased to work in the business for a reason that's not their fault, that it's not voluntary on their part. For example, if they become unwell and are unable to work in the business, if the company has to make them redundant, sometimes if they have to leave for some other reason that you are prepared to say is a valid reason that they shouldn't be penalized for. They've not done anything deliberate to harm the business. They've not left you in the lurch. Perhaps that might be a caring responsibility. You can choose to treat them as a good leaver. On the other hand, if they have committed to the company for, as in my example, a 3-year period, and they get a better offer and they decide to swan off into the sunset, leaving you holding the business and having to try and find a replacement at short notice, or having to work to cover their hours as well, then it's fair that they should be penalized for that. So in that circumstance, they'd be treated as a bad leaver. The reason for that difference is that typically you would have to pay a different price for the person's shares on their exit, depending on whether they are treated as good or bad leaver circumstances. Typically, a good leaver would be entitled to receive the market value for their shares, although a bad leaver might only be entitled to have back the money that they put in, or even a little bit less, to focus their mind on, we are committing for a period and we're all in this together. The we're all in this together also takes its place in the sale of the company. If you found a good buyer for your company, you found that you still hold 80, 90% of it, but you've got a minority shareholder for whatever reason. You found a buyer who wants the whole business. They don't want to have somebody as a minority shareholder coming along with them. You want to have the right to require that person to come along on the deal that you have done, so that you can deliver up the whole 100% of the company to your buyer if they want it. And that's referred to, quite picturesque phrase, as drag along. You are able to drag along your minority shareholder on a deal that works for you. The other side of that is tag along. You can probably guess what that means just from the expression. If you found a buyer for your shares, your minority shareholders don't necessarily want to be left in a business that's not run by you. It's being run by a stranger. So they want to be able to tag along with the deal that you have agreed and also exit at the same time and broadly on the same terms. These restrictions and requirements can be added at any stage in the process. If all the parties agree, it is possible to change these things and bring them in no matter what stage you are at. But it's always best to do it at a point where the parties are still friendly and on good terms. And that's typically at startup or at an exciting new phase for the company, because you can think more in the abstract about what's a fair answer, rather than finding yourself in a particular set of circumstances and looking at a particular individual. So you can say, in the abstract, if one of us wants to leave to care for an elderly relative, what would be fair? Because you don't know which one of you is going to be in those circumstances. Whereas when you find yourself in a real life situation, it's harder to make that change in a way that is objectively neutral and fair to everybody when you're in the heat of a situation. And I'm not quite sure what it says, but one of the most common times when I get people coming to me to look at formalising this arrangement in documentation is straight after Christmas, particularly in family businesses where families have spent a lot of time in close proximity and want to put their legal rights a little more down on paper. It was interesting, one of the results of our survey, I'm just going to remind myself of the figure, more than 80% of people who replied said they didn't have any written arrangements with anybody else who'd put money into their business, whereas there were almost 30% who had received money from somewhere other than their own savings. So if there's nothing in writing and it comes to an argument, it'll be interesting to see if both parties have exactly the same understanding to this level of detail. So typically a lawyer would give you a checklist of the things that you ought to think about, and you can agree those, and then we can convert them into the form of a document. And that's one of the things, that checklist is one of the things that we can provide to Michelle to circulate after the event. So you've got an idea of the kinds of things that you might want to think about putting into that sort of formal documentation.
We've actually got a question, I think, Sharon, that would be worth answering now. It's from Annie. What happens if a shareholder dies? Do their shares automatically transfer to their estate, or does it depend on the shareholder agreement?
If nothing different has been agreed, then shares are an asset, and like any other asset, you can leave them to whoever you want. But in the Articles of Association, which is the governing document of a company and is publicly filed, or in a shareholders agreement, which is a private document between the shareholders, you can provide for something different to happen. Typically, that would be the good leaver situation. If somebody has died, their shares would most likely be bought back by somebody else within the business, or at least the other shareholders or the company would have the option to do that if they were able to do so.
Okay. And then we have another question on good and bad leavers. Mm-hmm. Does the term, for example, 3 years, have to be written into the agreement? If someone leaves or resigns and there's no term documented other than an earn-out period, what happens? This is specific to where the shareholder leaving has not put money in.
One of the joys and one of the challenges of what I do is that we can document whatever the parties want. So if you want to lock people in for a specific period, you can do that. If you want to lock people in for a specific set of circumstances, you can do that. So no, 3 years was just an example because that's a fairly typical period for a business phase, at the end of which the investors might want to look at whether this has done what they wanted. What's the next stage looking like?
So would you advise including some sort of term or being as specific as possible, though, in terms of, developing your shareholder agreements?
Generally, yes. Although in some cases the business is more open-ended, so it's not clear at what point you would be able to leave without consequences.
Oh, okay.
It's in the context of the business at what point you can feel that somebody has earned the right to be paid market value for the shares to the value that they've delivered so far.
Okay.
Or to what extent actually them leaving is going to have such a detrimental effect on the company that the value of everybody's shares will be reduced, and therefore they should be also reduced for that future impact that they've had on their business partners.
Okay. And with this also, just because I know of quite a few businesses within the women's chapter community that have set up where they have quite senior level people who've come in to help with certain elements of them. It might be the financial side, so they're an FD, but they're working on an equity share rather than a salary. Would these kinds of agreements cover that as well? Because it might well be a case that 3 years down the line or 5 years down the line, they don't want to be in that role anymore and they want to cash in their shares and leave.
Yes.
Okay.
Absolutely. And those professional people would expect to be treated as good leavers as long as they had delivered on their commitment to you.
Okay.
And therefore be able to benefit from the value that they've generated from the business. On the other hand, up to the point at which they come, the value that's in the business is yours. You've created that value. So you could have a class of share that locks in to give you at least this amount of any value on a sale.
Okay, great. Thank
So
you.
it's probably an unusual thing to hear a lawyer say, but this is our opportunity to be creative. Whatever the parties want, whatever the parties feel is fair, we can make that happen. There are some restrictions to protect employees and the like from unfair treatment, but among grown-up commercial parties with reasonably equal bargaining power, English law is wonderful for allowing you to agree what you as adults feel is fair. The flip side of that is that it is important to get legal advice, because it is quite easy for somebody who knows their way around this to take advantage of somebody who is a little more naive.
Yeah, definitely. And I think that's certainly the case, I think, for a lot of creative businesses where the founder is a creative and very focused on developing that side of the business, and then there are people that like have more legal know-how, business know-how, that can come in and sway the level of advantage, I guess.
And to an extent, we're also paid to be the professional pessimists. We look at the what if this happened? Have you protected yourself? What if this bad thing happened? Have you protected yourself? Because you'll do this maybe once, maybe twice. Maybe you are a serial entrepreneur and will get very good at it. But most people build up a business once, whereas we see it day in, day out. We've seen lots of permutations of what can happen, and we can say, I've seen this. So one example, tragically, that I worked on, the client had got a very good investment and was committed to the business for a further 3 years, and was tragically killed in a motorcycle accident 3 weeks later. Wow. But all the lever provisions were set up such that his wife and family did very well out of it. At least they were able to be financially protected while they were dealing with the emotion. On the other hand, I've seen another situation where an individual had built up a business and for tax planning reasons had transferred some shares to his wife, who then became his ex-wife. He then transferred some shares to his new wife. And when it came to an exit, without having all those drag along and tag along rights, the ex-wife and the current wife could not be in the same room at the same time. It was horrific. So it's sharing with you the benefit of the what if and what could go wrong when you are feeling so positive and so excited about your business and your project. And then you've got us coming along saying, but this might happen, but that might happen. And ideally, we'll draft our documents, we'll put them in the back of your drawer, and you'll never look at them again. But it's important to protect yourself just in case.
Thank you.
Perhaps we should then move on to Louise to talk about your own personal position, now that I've talked about your company position. I'm conscious of time and that we do want to rattle through and hopefully let you all get away. Equally, if you want to stick around a little longer, we'd be happy to do that. So I shall mute myself, and Louise, let you to unmute you and take over.
Good morning, everyone. Can you all hear me all right? Is the sound working well?
Yes.
Good. I'm going to talk to you today about capacity and business. So sort of 3 key points really. Why is mental capacity relevant to you and your business? What are the risks to an entrepreneur? And what can be done to safeguard and prepare against these risks? I mean, I don't have to tell everyone we're living in absolutely unprecedented and uncertain times at the moment. We're in the middle of a global pandemic, and people during this time have been increasingly turning to their personal affairs and sort of aiming to get their affairs in good order. And this obviously extends not only to their personal affairs, but also to their business matters too. So today I'm going to talk about mental capacity, how it's relevant, as I say again, the risks and what can be done to safeguard against those risks. So the starting point is the Mental Capacity Act, and the basic principle is that an individual is assumed to have capacity unless proved otherwise. And as I'm sure you'll appreciate, it's been incredibly difficult in recent times to assess capacity. Recently we've had lockdown, we've got social distancing rules, and the past 6 months have really seen people spending most, if not all of their time at home, with very little outside communication or socializing, at least on a physical level. Thinking about why capacity is relevant to you and your business, I think it's always good to start with some statistics. And these are really quite shocking and surprising statistics. If we look at the recent report that was issued by Alzheimer's UK, that report confirmed that 1 in 14 people over the age of 65 are living with dementia. And it's forecast to increase to 1 million people by 2025 in the UK, and then further increase to 1.59 million by 2040. On a worldwide setting, there are about 36 million diagnosed cases of dementia and an estimated 28 million undiagnosed cases. And those figures are set to rise. By 2050, it's projected that 115 million people will be living with dementia worldwide. And the reasons are that we're a healthier and we're a wealthier society. People are living longer, so there's greater emphasis and need to protect against incapacity. Thinking about businesses in your lives, crisis management is incredibly important. If inadequate planning has been done, it's going to have a detrimental effect on normal business activities. And it may also seriously affect the value of your business for a potential sale or an exit. Turning our attention to the particular risks to an entrepreneur, if you think about your business, who is the key information holder in the business? If you weren't around, could the business still function? And as part of this exercise, it's important to consider and identify points of dependencies. Who has that business knowledge? Is it shared? Who manages client and supplier relations? Who has access to banking? Are there any other areas where the company relies on just one individual? If anything happened to that key person, who could take over the running of the business? Who could authorize payroll? How would contracts be fulfilled and suppliers paid? And we also need to think about not just those issues, but also the different business structures and the impact which that has on planning. For example, is your business a limited company? Are you a sole trader? Are you part of a partnership, for example? And this is all important because directors of limited companies, they cannot delegate their decision making. So in these circumstances, it's important to review the memorandum and articles of association of the business. Thinking about, for example, do the articles allow a director to be replaced quickly? Has a shareholders agreement been put in place? What does that say? It's important to know and understand your business. We had a recent case study in my department, a colleague of mine, and it was a case where a client was selling a large shareholding in a private company, and it was a multi-million-pound transaction. Unfortunately, in the middle of that sale process, the client had surgery and unfortunately ended up in a coma. So the whole sale process was effectively put on pause at that point. An emergency application was made to the court for a deputyship order, but the client sadly died before that application was completed. So this case just highlights the negatives of not having a contingency plan. There's lengthy and expensive court applications, which as a rough guide take between 3 to 6 months. There's uncertainty. You might lose a potential buyer. There'll be a loss of confidence, perhaps from investors and business partners, and it could potentially damage the reputation of the business that you've worked so hard to build up over many years. So thinking about what can be done to safeguard against these risks, one thing to think about is business lasting powers of attorney. So you may have come across lasting powers of attorney before and perhaps just viewed them in a very discrete personal sense, perhaps thinking about a lasting power of attorney where you would appoint someone to take care of your personal finances, your own bank account, etc. But it's actually possible to have a business lasting power of attorney, and they're made in very much the same way as a personal property and financial affairs power of attorney. The same rules apply, governing, for example, who can act as an attorney, the certificate provider, witnesses. But if you decide to make a business lasting power of attorney and a personal lasting power of attorney, each needs to contain instructions in section 7 of the form limiting their scope. So for example, if you did a personal power of attorney, you would specify that your attorneys could have general authority to act in relation to all of your personal property and financial affairs, except for the relevant business in respect of which you've executed a separate lasting power of attorney. And again, looking at that business lasting power of attorney, that would specify that the attorneys you've appointed in that document is specifically limited only to that particular business. And we can obviously assist and advise on preparation of business and personal lasting powers of attorney. Things to think about, you should always think about whether your choice of attorney is appropriate. So coming back to, as we've discussed, having a personal lasting power of attorney and a business power of attorney, someone that you might want to deal with your personal affairs might be completely not able to deal with your business affairs. You know, in perhaps your spouse, or your partner, you're happy for them to deal with your personal accounts and property, but they don't have the business acumen to deal with taking on the business if anything should happen to you. So again, just thinking about skills, experience, business acumen to be able to handle that role. Will appointing that attorney be a good move in terms of maintaining investor relations, business partner confidence? What about the reputation of the business? It's all key these are all key factors that you need to think about. So thinking about we talked about having instructions in your lasting power of attorney document. Thinking about specific instructions, is it necessary to restrict the power that you're giving to your attorney? Should that power be limited to one particular business? Or if you have more than one business, all of your businesses? And what you can do is put in place a letter of wishes to sit alongside your business lasting power of attorney, which covers topics such as which businesses this particular lasting power of attorney governs to avoid any clashes of authority. Maybe setting out what your business plan is for the future direction of the business, what your thoughts are on succession of the business, and any trigger points for exit or sale, just to have clarity in your thinking and setting all that down on paper. In terms of general planning, we've talked already about having a personal lasting power of attorney and a business lasting power of attorney, and I would definitely recommend both of those. And they can also be very tax efficient, because the lasting power of attorney for the business could be paid for by the business, the legal costs of preparing that. You should also think about having a will, making sure not only that you have a will in place, but also a will that suits your needs and that of your business. So you could consider having a trust of assets which qualify for business property relief from inheritance tax, so that there is scope for tax planning after the first death if you left your estate to your spouse or partner. Essentially, it gives you the ability to claim business property relief twice on the same assets, and we can advise further on this. But there's obviously scope for tax planning there. You should think about identifying points of dependency in the business, and make sure that that risk is spread and that you have a backup. Whether that's up training another member of staff so that they're able to step in if anything happens to you, or formalizing that by having a lasting power of attorney. Insurance is also a really good thing to think about. You could put in place some key man insurance Often this is quite cheap and effective and can be paid for by the business. So again, it's tax efficient. And then generally you might want to speak to a business expert, such as my colleague Sharon, about a general health check for your business, just to increase your preparedness. I mean, Sharon will be able to comment on what a general health check might look like and what it might entail. And succession planning can be covered as part of that general health check. So these are all key things that you need to be thinking about. And I'm happy to take any questions either later on in the discussion about any of the points that I've discussed. And I hope that this is helpful. And I'll pass on to Meta and Cecile for their next part of the discussion.
Thanks very much, Louise. That was really helpful. And if anyone, I see there are some questions in the chat. Some of them are relating to trademarks and IP, which I believe we're covering next. So for those questions, let's see how far we get on that, and then we can have a look at any other questions that have popped into the chat afterwards. Thanks very much, Louise.
Hello, can everyone hear me and Cecilia for the IP element of this discussion?
Yes, we can hear you. Thanks, Meta.
Okay, thank you. I'm going to be doing a next slide, please, instruction every now and then to whoever has control of the slides. Could we have our next slide? Lovely, thank you. Okay, so Cecilia and I are going to talk about IP. It's going to have to be a bit of a whirlwind tour, I'm afraid, because I'm conscious that time's ticking on. I just wanted to start off by talking about why entrepreneurs and business founders should be interested in IP. Obviously, I would say that it's fundamental, but really, this is something that transforms the innovation and creativity behind your business into market value at the end of the day. It makes you more competitive. It's a way of protecting new technologies, your brand, your names, your logos, designs, basically anything creative about your business concept. It also helps you keep sole ownership of business concepts going forward. And if used as an asset, it's something that can really help you secure investment, which is clearly all important in a small company's early days, and thereby grow market value as well. Next slide, please.
So the main types of IP rights are trademarks, patents, copyright, and design rights. So we're going to give you a brief overview of those rights, and with a particular focus on trademarks and copyright. And we'll also explain the meaning and importance of the symbols that you can see on the slide. In addition to those 4 IP rights, there are also what can be called quasi-IP rights, which are confidential know-how, trade secrets, and domain names. And we briefly talk about confidential information and trade secrets later on. Next slide, please.
So this slide really is to demonstrate the power of branding as a way into talking about trademarks a bit. Hopefully these logos and slogans and objects will instantly call to mind some of the world's most well-known brands. And it can show you the different types of trademarks there are. So for example, you know, you've got the Apple logo, the shape of the Coca-Cola bottle, the I'm loving it logo, or even sounds like the Intel dung 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 jingle, which we all know very well. Hopefully I'm showing my age horrendously there. But these things should be easily identifiable, and it kind of really shows the power of trademarks as a start. Next slide, please.
So as Meta explained, a trademark is really a sign of origin. So it indicates where a product or service comes from, and it's going to distinguish one trader's products from another. So trademarks can be registered or unregistered. So if it is registered, then you can add the little R in a circle. And if it's not registered, then you can use the letters TM. Having a registered trademark is much more powerful than having an unregistered trademark, because used in conjunction with the little R in the circle, it's going to warn others of your claim to that mark, and it's going to act as a deterrent in case, well, other people might be less likely to infringe your mark. Also, if you have a registered mark, you're going to have a much more straightforward claim if someone else starts using a similar mark to yours. If you have to rely on unregistered marks, it's a lot more complicated. So what can be registered as a trademark? The easiest things that you can register are logos, words and slogans. You can also register the shape of goods or their packaging, sounds, smells and colours, although in practice it's a little bit more difficult than logos, words and slogans. So the big advantage of trademark is that it's pretty much the only IP right for which you can have forever, as long as you use it and renew it in time. You can either apply for a national trademark, which is going to cover the UK, or you can have an EU trademark, which is going to cover the whole of the EU. But you can also apply for an international registration where you register the mark in several countries of your choice. I mean, this obviously has a cost, because the more countries you register the mark in, the greater it will cost you. So I've mentioned EU marks. I'm just going to say a few words about Brexit. And what I'm going to say also apply to registered design as well, to trademarks. So currently, if you've got an EU trademark, that covers the whole of the EU, including the UK. But after 31st December this year, it's not going to cover the UK anymore. However, if you've already got an EU mark, there are provisions in place so that your EU mark will give rise to a new UK registration, which will have exactly the same details, and so you have the same rights in the UK. You won't be losing your rights. Next slide, please.
We said this was going to be whirlwind. Moving swiftly onwards to copyright. Copyright is probably best known as the thing that protects things like artistic works or literature, music, that kind of thing. But actually it also covers things that you might not necessarily expect, such as computer software, and in particular the code that underlies computer programs, which makes it quite important, particularly in this AI digital world. It's great because it arises automatically on the creation of an original work. Once that work is fixated in some permanent way, so it's written down, it's committed to paper or typed up or saved in some permanent form, and no registration is required in order to be protected by copyright. However, the thing is about copyright is that you need to be able to assert it, and the best way of doing that, a really good habit to get into right from the word go in any kind of commercial context, is by using the copyright notice, which in the standard format tends to be the word copyright, the little copyright symbol, the C in the circle, and then the date that this work was created along with the name of the owner. So in this case, it's Collyer Bristow. But that little formula is something that really ought to be stamped on anything that you create in the context of your business or that you're sending out to other people, so that they know who owns what. Because as Cecile will go on to discuss a bit later, ultimately with IP, that's kind of the first thing you need to prove if you're trying to stop someone else doing something, is prove that you actually own what you say you own, and why you should have that power and that right. Next slide.
Meta, can I just ask a question about that? Do you need to change that date for each year? So in other words, in 2021,
no, it's the date on which the work was created.
Okay.
Yeah.
So if you've got, for example, I see it a lot on kind of like consultant PowerPoint decks, or when people are talking about their offering, that would be basically on the date that it was created, and you can continue using that for however many iterations of that you may have.
Yeah, I mean, obviously, if you tinker with the slide or change it and sort of give rise to a new version of it, then you might want to change the date because it's a different work. But yeah, really, it's the date in which the work was created.
Okay, thank you.
So copyright protects the expression of ideas, but not ideas themselves. So, for example, if you write a novel and someone copies your theme or ideas of your plot, then they are probably just copying ideas which are embedded in your novel, as opposed to copying the novel itself. So probably there wouldn't be any infringement. There has to be a certain quality of the copyright material. So a material which is very short, such as a name or a short slogan, is unlikely to be protected by copyright. For example, ESO sought copyright protection for the word Exxon, which was a word invented and used as a trade name, and this was held not to be protectable by copyright, as this was just a name. So copyright provides you with protection against copying, so you can prevent others from copying your work. But it's important to note that it only protects you if there is actual copying. So if someone else creates something which is very similar to your work, but they've created this completely independently, then there wouldn't be any copying, and so there wouldn't be any infringement. One of the big advantages of copyright is that the protection is very long lasting. So there are different timelines depending on the type of copyright work. But basically for literary, artistic, musical and dramatic works, the protection lasts for the author's life plus 70 years after death. And for computer generated work, it's slightly shorter, it's 50 years from the date of creation.
Just to ask Cecile, so that protection is in place if you use that little slogan at the bottom with the C inside the circle?
No, you don't have to use the little notice. Yeah, so as soon as you create a work which is, can be protected by copyright, I mean, copyright arises automatically. You don't need to register it, and you don't necessarily need to add the little notice, but it's best practice to do that, to add the little C, as Meta mentioned.
And what advice would you have? Because I know this is very common with small businesses where they have something that creative or a design or something that gets ripped off by someone much bigger who has a lot more legal clout and money. What's the best way to protect yourself from the outset against that sort of scenario? Where, because I think in one of our previous events we had the owner of a clothing brand whose designs were subsequently ripped off by two very large businesses or clothing houses, and she did win, but it took a long time. So is there anything that smaller business owners can do at the outset and proactively to protect themselves or put themselves in the best possible position when it comes to those sorts of situations?
Well, I think we're going to come to that a bit later, but
okay, great.
On what it is, you can register your brand, or I mean, with copyright there's no registration process, but if it's a design, you can also register design rights. So there's different things you can do
Great.
protect the products.
It also depends how that other company comes by your design. I mean, if it's something that you've sent to them as a potential kind of, I don't know, tie-up or collaboration effort on a document, for example, then you ought to be asserting your copyright ownership in anything that goes their way and stressing that stuff is confidential. But as Cecile said, we will talk about this a bit later on.
Brilliant.
I think designs are sort of next up, actually, aren't they? Can we have the next slide, please? Right. Okay. This is I'm not going to say everything that's on this slide on the basis that these are going to be recorded or circulated afterwards, but hopefully this is useful. Designs sort of sit in the space in between what copyright protects and what patents protect, in that they protect the shape of things. So design for a car, clothing, the shape and configuration of something, but not necessarily how it works. And they're probably sort of the shorter end of duration in terms of how long they protect things for, as you can see from the second row down. And there are various different types of design protection. There's the registered rights that you can register, whether in the UK or the EU, or there's the kind of the automatically arising unregistered rights, which are obviously much shorter and protect slightly less in terms of their scope. I think that's probably all I can say, because I know how stressed we are for time at the moment, so I'm going to leave it there. But obviously if there are questions about design rights, then we can deal with those separately. Next slide, please.
So patents, again, I'm not really going to explain patents in great detail, but they also have a shorter protection because they give you a monopoly right for 20 years. I think the one thing you should really remember about patents is that if you come up with an invention which you think might be patentable, you really have to keep it confidential until you have applied for a patent. This is because as soon as you start telling people about your invention, if you don't do that in confidence, it will invalidate any subsequent application that you make, because your patent won't be new anymore. So if you have to disclose your invention to other people before you've been able to apply for a patent, you should make sure that you have a non-disclosure agreement in place before you do so. Next slide, please.
And that kind of takes us quite nicely into the quasi rights, the confidential information, the trade secrets that we mentioned earlier. Because if you want longer protection than 20 years and you don't want to go down the patent registration route, I guess one other option is just to keep the secret information secret. And a famous example of this is the Coca-Cola formula that they use in their drinks. The thing about secret information is that if someone goes rogue in your business and spills the beans, then that information is no longer yours, and therefore businesses have to kind of keep in mind various ways and tactics for trying to disincentivize that kind of leak, and making sure that everybody knows what's confidential and how to keep it that way. And one way of doing this, as Cecile has just mentioned, is having non-disclosure agreements in place with any information that's leaving the safety of your organization, or indeed in the case of employees who are leaving, etc. Although there are other contractual provisions in place for those, which we'll talk about a bit later on in the slide. And also, marking documents confidential if they contain information that shouldn't be disseminated further, because then there's no way that whoever's spilling the beans can say, oh, I didn't know. And that's really, really key, making sure that you impress upon people the nature of the information that they're supposed to be keeping private. With employees and consultants, again, it's worth getting this right from the word go. You want to make sure that any contracts you have in place with people have proper confidentiality clauses to make sure that those are all completely watertight. And also think about restricting access within your organization as you grow. Does everybody that you employ need to have access to everything? Because it's worth restricting it to people who actually need to be in the know if you possibly can, and use sort of encryption or password protecting areas, firewalls, that kind of thing, because that's one much more kind of proactive step that you can take to keep things secret if they need to be kept secret. Next slide, please.
So I think our advice to entrepreneurs is that it's never too early to think about IP, and everything will be far easier if you get everything right from the start, or at least at an early stage. You need to think about who owns the IP rights in what has been created so far for your business. So if you have employees who create a copy or a work or an invention, then as the employer, you will automatically be the owner of those IP rights, in the UK at least. But if you've hired a consultant or a freelancer, then the IP rights arising from the work they've done for you will be owned by them, unless you've got a contract in place which provides otherwise. So when you ask a third party to create something for you, such as a logo for your brand, for example, you need to make sure that you have clauses in place or an assignment agreement under which the third party will assign its copyright or other IP rights to you. So I think there's a recent case which illustrates the importance of having clear agreements in place, and that's the Innocent Smoothie case. So Innocent Smoothie asked a design company to design a logo for their brand, which is the logo you can see on the bottle. But they didn't have an agreement in place. And 15 years later, the design company tried to stop Innocent Smoothie to claim rights in the logo, and this turned into a court dispute. So as you can see, I mean, if they had a proper agreement in place from the very start, they wouldn't have had an agreement in court, and they wouldn't have spent lots of time and money fighting for this. So it's very important, especially for a key asset like a logo, that you make sure you've got all the paperwork in place to make sure that you own all the rights. It's also important that you keep records, as Meta mentioned earlier, of all your creations and inventions. You need to keep a record of who created what, to get together with any agreements you might have in place. And also you need to have clear timelines of when the work was created, because this is going to be very useful if there is a claim, because ultimately what you need to prove is that you were the first one to come up with that particular thing, with that particular material or brand, because with IP rights, what matters is that you were the one to come up first with that material. And also it'll be very helpful because you'll be able to prove that you own the rights, the IP rights in that material. Another thing is that you should think about registering your trademark early on, before someone else's does, and also before you decide to, pick a specific mark or brand, you should do a clearance search to check that no one else is already using a similar or the same name for similar goods or services, because if it turns out that there's already someone out there using a similar brand, then you might as well pick a different brand from the start. And also you should think about in which countries you want to expand. You shouldn't just look at the UK, but check other countries where you think you might expand later on. Next slide, please.
And then finally, just a quick word about enforcement in case of if everything goes wrong. Basically, I think our fundamental piece of advice here is get specialist IP advice, because it's just a very separate aspect of law, and there are lots of particular rules that apply that people might not know about. Another thing is that a lot of these rights are territorial, so the rights that you have in the UK may not be the same elsewhere. And in the age of social media and sort of online business, it's just too easy to take something from someone's website or from social or like Instagram account, use that without any real concept of who owns that and where they are in the world. And you don't want to find yourself on the receiving end of something that you don't need to be on if it involves a legal dispute. Another quick word is that we have specialist disputes for particular IP litigation and other kinds of matters that need resolving. In the UK, we've got something called the Intellectual Property Enterprise Court, which is a kind of specialist part of the court that deals with IP disputes only, with specialist judges. And it's I think it was originally intended to be a sort of cheaper and faster alternative to high court litigation, and to some extent that's true, although at the moment the timeframes are probably quite similar. But that is, something that is worth considering, particularly because it involves capped costs, so you can limit your potential exposure if you lose in court in the end to having to pay the other side's legal costs, which is the kind of the default position in the High Court. So it could be a cheaper place to litigate for that reason. But it doesn't necessarily have to be court, and indeed the UK IPO, the Intellectual Property Office, and its EU cousin, the UFO, also deal with trademark and design disputes to an extent. And also in the cases of, for example, things like domain names, if you think someone is using a domain name that they shouldn't be because maybe it infringes on your trademark rights or something, you can ask the World Intellectual Property Organization to use their domain name dispute resolution procedure. So that's not strictly speaking a kind of court action, it's separate, and it can be very useful in particularly in case of international disputes with people. And it can be much cheaper and faster as a way of resolving these kind of issues. So these are things that we can talk to you about as and when needed. And then finally, I just wanted to say, why would you litigate? Well, because of what it can achieve, and the kinds of things that courts can order in the case of someone infringing on your IP are things like obviously damages. They can order the infringing party to make an account of their profits from selling the things they shouldn't have been selling to you. I mean, a lot of the time, actually, what people want is an injunction to say, stop doing what you're doing. So that's kind of the main objective, and damages on top of that are nice, but really we just want them to stop. But also there is slightly more kind of I don't know, well, there are other remedies as well, including things like the court ordering the other side to publish an apology for infringing your rights. They can order the rights to be transferred to you if they're registrations at the end of the day, and if they were misregistered in the name of the wrong party. And also, if you find that there is a warehouse of infringing goods sitting somewhere, you can ask the court to order that they be destroyed or delivered to you at the end of the dispute as well. So I mean, these are the kind of things that can be done in the case of someone else infringing your rights. And I think that's probably very much all we have time for, so I'm going to leave it there. And I don't know if we've still got time for the Q&A, but I'm going to pass it back to Michelle. So thank you.
Thank you very much, Meta and Cecile. That was really, really helpful, and Louise as well. Thank you so much. I think we've actually we've had Patrick and Sarah answering questions in the chat as you guys have been chatting. So I think it's probably safe to say that if there is anything that's gone unanswered, perhaps we can circulate answers to those questions. So I'll download a transcript of the chat, and if there's anything that we haven't covered, we can do that and send that round to everybody. If that's okay, because yeah, I'm conscious we've gone over, and I was also asking lots of questions too, so it's getting quite excited over here. But yeah, I mean, that was really, really helpful. Thank you so much. And I think to everybody on the call, hopefully you found that helpful as well. I certainly learned some things myself, and have been generating a little list here of the things that I need to check off. And perhaps that's something that we can circulate as well, as some sort of a checklist of kind of the key things that people need to make sure that they've considered and taken some action on, to at least have a basic level of protection for themselves, both personally, but also for their businesses. So that's really, really helpful. Thank you so much. I'm going to switch now just quickly to the gallery view so that we can see everybody. But I think, yeah, without keeping you any longer, thank you very much, Sharon, Meta, Cecile. That was really, really helpful, and I can see there are lots of smiling faces and nodding going on for our participants today. If you do have any questions, I will be circulating obviously a roundup email afterwards, so feel free to respond to that, and I can direct your questions to the right people. I'll also have email addresses for Sharon, Louise, Meta, and Cecile in the follow-up email. So if that's okay with all of you, if anyone has anything that they'd like to direct to you specifically, they can do so. So thank you very much, everyone. This will be recorded, so I'll make sure you get a copy of it as well as the slides. Thank you very much.
Thank you.
Brilliant.